title of this case is U.S. Embassy holds visa over 500 days. Visa applicant files Mandamus lawsuit. Was the delay lawful or simply bureaucratic stonewalling? Today is Wednesday, June 18th, 2025. Let's take a look at this case. So this case, there's a quick summary, is that there is a visa applicant that filed for a B1, B2 visa, and he's now suing the U.S. government after waiting 500 days with no decision following a consular interview at the U.S. Embassy in Abu Dhabi. The complaint alleges that the extended delay is an unlawful under the Administrative Procedure Act, and the lawsuit seeks a federal court order compelling action on the long pending visa application. So that's pretty much the gist of this case. Let's just review this case. So this was filed at the U.S. District Court of Columbia. We see a lot of these cases filed at the District Court of Columbia since the defendant seems to have offices there, or they have offices actually there. Here is the plaintiff, and here are the defendants. For the defendants, he named the U.S. Department of State, that is the Secretary of State, the Assistant Secretary, Bureau of Consular Affairs, the Deputy Chief of Mission at the U.S. Embassy in Abu Dhabi, and an consular officer, an unknown consular officer is named as John Doe at the U.S. Embassy in Abu Dhabi. So those are the defendants that the plaintiff has named in the lawsuit. So we can take a look at the specific nature of this lawsuit. So this complaint, again, complaint is allegation, right? So it's alleged this is a writ in the nature of a mandamus and also in violation of the Administrative Procedure Act. All right, when we look at the introduction, so here we have one plaintiff, and the plaintiff is claiming that this action is brought as a result of the defendant's failure to adjudicate plaintiff's B1, B2, and B1, B2 is a non-immigrant visa. So it is a non-immigrant visa application within a reasonable period of time. The plaintiff is seeking a writ of mandamus to compel defendant to complete the adjudication of plaintiff's B1, B2 visa application within a timely manner, alleging violations of the Administrative Procedure Act. And the applicant, like I mentioned, is a B1, B2, filing for B1, B2, a non-immigrant visa. He is saying that completed the application on November 21st, 2023, and the required interview at the U.S. Embassy in Abu Dhabi in the United Arab Emirates, and his application remain unadjudicated. And he did attend a non-immigrant visa interview on November 22nd, 2023. It's interesting is that when I look at the application, it looks like the application was filed on November 21st, 2023, and the day after he got an interview. It seems awfully fast to me. Okay. All right. The interview was at the U.S. Embassy in Abu Dhabi, UAE, and thereafter, they're claiming that the plaintiff's application was placed in an administrative processing and remains in a continued state of administrative processing for over 1 year and 4 months. So not having received any communication regarding the pending B1, B2 filed with the U.S. Embassy in Abu Dhabi, UAE, plaintiff was forced to seek a writ of mandamus. So again, the issue is, you don't know which way the embassy is going to rule, because non-immigrant visa, even the green card, is discretionary depending on the consular officer. I mean, they have a lot of these officers have a lot of discretion on whether to grant this visa, especially a non-immigrant visa. So all right, let's just read through it again. Read some more. Plaintiff has a clear right to adjudication. Which way he's going to adjudicate, who knows? Adjudication of his non-immigrant visa application within a timely manner. The delay is making a decision. The delay in making decision on plaintiff's visa application extend well beyond the Congress gone on 180 days for immigrant benefits. All right, so immigration is a benefit. Final adjudication of the visa application is ministerial, non-discretionary task. Defendant are in violation of the Administrative Procedure Act. It's interesting. So for the parties, he named quite a bit of people. Again, this is the plaintiff, resident of Dubai, United Arab Emirates, is seeking a B1, B2 non-immigrant visa application. And then they're going to name all these defendants. So the defendant, Secretary of State is named, Department of State, defendant, acting principal deputy assistant secretary of state for consular affairs is named as a defendant. The deputy chief of mission of the U.S. embassy in Abu Dhabi has been named. And when I looked at the actual case, it looked like summons has been issued, and I don't know if they've been served yet, but this case was filed April 17, 2025. So I'm assuming they have already been served. Okay, so the defendant, John Doe, who was a consular officer, is also named. Okay, so the jurisdiction, it says the court has additional jurisdiction by the virtue of APA, Administrative Procedures Act. The venue is proper in the district court for the District of Columbia. And then the exhaustion, they're saying that plaintiff has repeatedly requested defendants to make final decision on his visa application, and the plaintiff has exhausted his administrative remedy. So we're going to go through some of the factual allegations I think we have already covered. I think they're going to go into a little more depth. So it says on November 21st, 2023, we already knew that, has successfully submitted his DS-160 through the application center for the B1, B2 non-immigrant visa. Like, non-immigrant visas are discretionary. It is up to the discretion of the officer whether to grant it or not. But okay, he thinks they're waiting too long. And then November 22, 2023, November 22nd of 23, he appeared at the U.S. Embassy in Abu Dhabi, UAE, where he completed his consular interview for application filed on 21st, 2023. At the conclusion of the interview, he was informed that his visa application has been approved, that it will be issued within the coming days, yet no visa has been issued. Despite having been informed that the visa application has been approved, plaintiff visa application remains unadjudicated pending the completion of administrative processing. Since issuing the notice of administrative processing, defendant have not made any requests for further information or evidence from plaintiff, and numerous inquiries over the past 16 months regarding non-immigrant visa application, and the inquiries have not resulted in meaningful response. And it's saying the application now continues to be pending with defendant for over 1 year and 4 months since he completed his non-immigrant visa interview at the U.S. Embassy in Abu Dhabi, UAE. And the defendant have refused to provide any explanation which would merit the need for over 16 months of administrative processing, given that his application was initially approved. Okay, so these are the counts. They're saying violation of the Administrative Procedures Act for the form DS-160 for the B1, B2. And they're saying that the plaintiff has statutory right to apply and receive an adjudication of the B1, B2 non-immigrant visa. There's no other remedy available to the plaintiff. Given that the defendant's lack of reason for not making a decision on this visa application for 16 months, they're saying that they're in violation of the Administrative Procedures Act. And then in terms of what they're requesting the court to do is to compel the defendants, those acting under them, to perform their duty to adjudicate plaintiff's non-immigrant visa immediately. So yeah, it is interesting. Usually you don't see this type of writ for mandamus for non-immigrant visa. But anyway, I thought it was an interesting case. Again, if you like this, give me a thumbs up. Press the like button, press the subscribe button so I can bring more of these types of interesting lawsuits that are in public records. These are in public records. Thank you very much for your time. Thank you. Goodbye. Bye-bye.